Afternoon, the jury got to see security video of the shooter carrying out his massacre on November 30th, 2021. The father of the shooter did not look up to watch that video and kept his head down the entire time. A member of the jury cried, as did the father of Justin Schilling. The video was played after the prosecution introduced portions of the shooter's journal, a journal that Crumbley fought against.
I will have to find where my dad hid my 9mm before I can shoot the school. Unfortunately, my dad does not want me to get the 9mm gun, and we are having financial problems, RN for right now. And I don't have a job, so now I'm pissed because I want to do the shooting with a 9mm pistol, as they are effective for killing.
As those journal entries were being read, Crumbley kept writing notes to his attorney. Earlier in the day, the prosecution played a video of Crumbley in the back of a police car with his wife, as an Oakland County detective testified that he had been cooperative with them. In fact, James Crumbley gave him a rundown about where the guns were in the home. As they searched the home, police found 2 empty magazines, some ammo, and a gun safe where there was a .22 caliber handgun and a Derringer that Crumbley bought months before the shooting, and as we learned yesterday, used to take his son to the range. Police say they found the gun safe unlocked, and as you heard earlier, it was never changed. Prosecutors have also indicated that the case for the 9mm used in the school shooting was never locked up, and the gun lock that came with it was also never used.
And this is exactly how we saw it when we did the initial search of the house, and then when we came back in once the search warrant was granted. This is how it was.
Morning at 9, the state is expected to rest its case. Then the defense will start calling its witnesses, and we will see if James Crumbley will take the stand. Reporting in Pontiac, Andres Gutierrez, CBS News, Detroit.
We want to bring in our legal experts to help us weigh in on what we've seen so far.
Attorneys Terry Johnston and Rick Convertino join us this morning. Thank you both for being here. So, you know, it's just so interesting because we were saying how at this point in the trial, I feel like you were already calling it, Rick. You were saying this is going to get a guilty verdict. And especially after Jennifer Crumbley's testimony, you said this is done.
Yeah, I thought it was a foregone conclusion after her testimony.
This is done, but right now, we're not so sure. It really could go either way.
It certainly could. It can go, you know, one of 3 ways. It can be, you can have a hung jury, which is at least one juror who is inconsistent with the remaining jurors. They can be inconsistent either way, guilty or not guilty, and unwilling to change their vote. And there you'd have a hung jury. You could have, of course, an acquittal and, of course, a conviction. Those are the 3 options. I think it's very possible that the first 2 may occur. I think it's possible that there's a hung jury in this case. Well, of course, we haven't heard anything from the defense yet, but I think there's reasonable doubt at this point in time. At least, you know, you want to go into a closing argument as a defense attorney with the, you know, with ammunition. You want some arrows in your quiver.
Questions.
And to argue your reasonable doubt, to argue that attenuation or that you know, that gap between the evidence and reasonable doubt. And remember, reasonable doubt is not, you know, not a doubt beyond all shadow of a doubt or beyond every doubt. It's just it's a doubt based on reason and common sense. And so you have to argue that hard. And here I think there is plenty of ammunition or arrows to fire regarding reasonable doubt. And among them are what we just saw in Andres' piece regarding, you know, I can't find the gun. My dad hid the gun. So whether he hid the gun because for safety purposes, or he hid the gun because he thought his son, you know, had potentiality for using it and for, you know, for something like this, all of those are still up in the air. But the defense attorney at this point has enough to argue hard for reasonable doubt, and that's really what she needs. And she can take that away if James Crumbley testifies and does a poor job. So I don't think if I were she, I would strongly recommend that he not testify.
I agree with you. I'm sorry.
Go for it.
No, I agree with you. I mean, and here's the thing, at this point, what defense do you need to put up? I mean, seriously, because when you put up a defense, you're bringing someone to the stand to say what? If I already believe reasonable doubt exists, why would I bring someone to the stand to take that reasonable doubt away?
And it shows a confidence as well, doesn't it?
It's not necessarily a confidence as much as it is a strategy.
Maybe an arrogance.
Well,
you know,
I mean,
to propose your witness at this point.
yeah, I mean, if you look at it from the standpoint of, if from a strategic standpoint, if I believe I'm ahead or at least even, at that point, what I'm going to do, once the prosecution rests their case, I'm going to do my motion for directed verdict. We have to do those. I mean, they're rarely granted. I've had a couple, but again, they're rarely granted. And then I'm going to say, Your Honor, at this point, she's going to ask Mr. Crumbley if he wants to testify. Hopefully he does not. She says, Mr. Crumbley says no. And I expect, if it were me, I'd turn to the judge and say, at this point, Your Honor, we rest. And watch the prosecution scramble, because they're expecting witnesses. They're going to probably say, well, Your Honor, we're going to need some time to get together for our closing. We're not prepared. Can we do this tomorrow morning first thing? That's what I anticipate, depending on when the prosecution starts to close.
And here's something that's really...
Would you agree with that?
I do agree with that. Here's something that's really, really important to consider when you're a defense attorney. If you present any evidence in your case in chief at the conclusion of the prosecution's case in chief, so now you go, the prosecution has the opportunity to present another case called rebuttal. So they're able to take what Jennifer said in her statements when she testified and bring in evidence in by other witnesses. So I always would save witnesses for rebuttal. So in case you need them, and that can be very, very powerful. So defendant can get up, make some points, and you're left with the impression, okay, I see where he or she answered this question or explained themselves here. And then you hear from the prosecution's rebuttal witnesses that disseminate information that decimates that. And that can be, that is a strategy that you want to keep in mind as a defense attorney. Well, I don't want to open up anything else. I can add to my case. I can make it, I can, smooth some edges, but at what cost? Is it a Pyrrhic victory? Right. Am I going to get hammered in rebuttal and lose all opportunity to argue reasonable doubt on certain pieces of evidence?
And in her closing, it would be, if it were me, I have questions. Here are my questions. They didn't show this. I have questions. And what are questions that you don't have answered, ladies and gentlemen? It's called reasonable doubt. And if you give the prosecution the opportunity, or even the jurors the opportunity to answer those questions, sometimes, again, it's the old saying of, you don't put someone on the stand, or you don't ask a question where you don't know the answer to. I think at this point, just based on what I've seen so far, I don't think the defense scores any more points if they put on a defense at this point, unless something happens where the next prosecution witness is so damaging. And when I say damaging, I'm not talking about an emotional witness. I'm talking about somebody that comes up and they see this gun and James Crumbley and his son doing some things that he shouldn't have been doing with. Something like that would be damaging, but I don't see it at this point.
Would you bring any witnesses in your experience as a defense attorney? Would you bring any right now?
Right now, no. Again, if I think I have reasonable doubt out there already, what witness can come out and say something that's going to help me more? I don't know. I mean, the purpose, remember, let's go back to the core principle here. It's up to the prosecution to prove their case beyond a reasonable doubt. If the defense attorney wants to sit there and put her feet up on the table and, do crossword puzzles on her phone, and never ask a question, and the people don't prove their case, then they don't prove their case. She does not have to prove anything. The burden of proof completely rests on the prosecution side.
And that's a specific jury instruction that's told
Right.
to the jury, and that is memorialized and goes back with the jury, that there is no burden upon the defense to present a case or to present any evidence whatever. It's the sole burden in this case is upon the prosecution to prove each and every element of each crime beyond a reasonable doubt.
And the ordinary care, based on our conversation earlier today, I don't know that they can prove ordinary care. I mean, looking in my closing, I would say something, look at what his son said. He couldn't find the gun. I have to find it. What does that tell you, ladies and gentlemen? It tells you that the gun was hidden. It doesn't say, I'm going to wait for them to leave and I'm going to go get it. I have to find it. He, being the son, had to take other steps to do things. So I think that right there is powerful enough to go back to hit just one element, just that one element.
It's an example of when you might want to present a witness as a defense attorney in this case. You'd want to be strategic, and you want to remember that when you present something, there's the possibility of a rebuttal, of rebutting that particular witness. So, like Terry was saying, it was an excellent point about the gun lock. Let's say the defense had the gun lock independently tested, and the gun lock had residue, gunshot residue on it, which would indicate that it was put in the barrel of that weapon at some point, which would obviate the prosecution's theory that it was never used at all. It's an indication that it was used. So you'd present that evidence through an expert witness. They did a series of tests, and yes, this gunshot residue was on this gun lock. That's the kind of witness you might want to put on to show that the gun lock was actually used at some point in time. So, that's not much you can do with that on a rebuttal. Right. Rebuttal.
And it's good food for thought. We do have to take a short break. You can catch the trial over on CBSDetroit.com.
And once things get started, we'll have uninterrupted coverage for you on our website, CBSDetroit.com, Pluto TV, and the CBS News app. We'll be right back. Welcome back to our special coverage of the James Crumbley trial. We want to bring in our legal experts to continue the conversation about what we've been seeing.
Yeah, attorneys Terry Johnson and Rick Convertino join us this morning. Thanks so much for being here. So before the break, we were talking about whether or not defense attorney Muriel Lehman will bring in any witnesses in her case. And I did receive a viewer question last night from Donald in Ann Arbor, who asked, why have we never heard anything about the art studio owner? Could that person be an effective witness? Because there's been a lot of debate. This is, of course, the art studio where the Crumbleys were, some people would say, hiding out. They would say almost taking shelter because they felt that their home was no longer safe after this attack. Yeah, what's your take on that?
I don't know what the art owner would bring to the table, quite honestly, in terms of the charges that are before the jury at this point is, involuntary manslaughter. And I'm not sure, unless the Crumbleys said something along the lines of, we never should have given him the gun, or we never should have purchased the gun for him, or we're bad parents, or something along those lines. Other than that, I just don't see what this particular witness or potential witness could add.
Donald had a good question, because here's something that is certain beyond all peradventure, that the art studio owner where they stayed was questioned by law enforcement. And as a result of the questioning by law enforcement, that person has a 302 or a Oakland County Sheriff's Department form, whatever, that memorializes that statement in toto. And so both sides of this case in discovery would have that statement by the art studio owner. And so I can only say that if there's anything that would have been productive for the prosecution or the defense, you would have heard about it by now, because they definitely interviewed him and got all information they could from him. So he probably didn't say, protecting his own self-interest, didn't have much to say. He said that they were acquaintances. They asked if they could stay there, and he had agreed. But any statement that they made to him would be an admission by a party opponent, which would be admissible. And so that didn't occur. Any exculpatory, inculpatory statements made would have also been used by either the prosecution or the defense, and that clearly wasn't done. So, but the information was gleaned from him. He was interviewed, I'm sure, and had nothing worthwhile to say that would propel either case.
Interesting. So they reached out to him.
They would have reached out to every conceivable witness that was even remotely possible. And they interviewed hundreds and hundreds of witnesses.
Sorry, I meant the Crumbleys reached out to him to stay there.
Yeah,
is what I
evidently
understand.
they did. Yeah, Jennifer Crumbley said it was a friend.
Okay.
In her trial, she said he was a friend, and I think she said that the friend offered, said you can stay here for a night or so. But let's assume that Jennifer Crumbley told this person at the art studio, we need a place to stay because tomorrow morning we're going to turn ourselves in. Mm-hmm. Now that would have been important information, exculpatory information that would have been favorable to the Crumbleys, and that would have been admissible through the art studio owner as a statement by a party opponent, and that would have come in. So that evidently wasn't said. So it may have been just some, hey, you want to flop here, you can, here are the keys, or because he wasn't there, and it didn't appear that that he had stayed there. They brought in somebody brought the mattress in for them to sleep on. It wasn't there. That was the witness testimony of the coffee shop owner.
And I think the defense attorney did a great job of asking some questions yesterday along the lines of, when you walked in, you didn't see them hiding, you didn't see them, under covers trying to avoid you or anything along those lines. I mean, because again,
they were faking they were asleep.
Well, I think one of them had, I think Jennifer had X amount of pills or something, so I don't know if she was faking or not, but yeah, it's, again, I think it's just been a remarkable difference between the questions that have been asked here versus the questions that were asked. And again, there are two different trials, and some questions do pertain to Jennifer and some questions don't, but it just truly comes down to...
But the interesting thing to me is that you have two different trials with the same evidence. So the gravamen of the case was the same, but it's just the way that the defense attorneys crafted and perfected their skills, which made a huge difference.
All about a well-crafted defense.
It is.
Is what we're seeing here, and it's pretty astounding. It's astounding to see. If this ends differently than Jennifer's case, I mean, that's shocking, isn't it?
It would be incredibly shocking.
No, it wouldn't be shocking, because again, if you go back when we first started this, one of the things we talked about was this is a completely different case. Remember, you've got 12 different jurors, right, who are looking at this from the evidence that this attorney presented.
But the crime in question, the act in question is the same. The charge is the same.
Correct, but again, you've got two different players. So think of it from like a football game, right? I can have if I change quarterbacks, and you know, even though everything else around me is the same, what the quarterback did could potentially change the outcome of the game. So that's how I'm kind of looking at it. Even though it's, let's say, Michigan State versus Ohio State, I change quarterbacks. It's still Michigan State versus Ohio State. But what did this one person do? You know, did he hand off? Did he make good throws? Did he make good, good decisions? Though that's why this is a completely different trial, even though the evidence and everything else is the same.
The other thing to consider is why are there two different trials? Remember, they were both charged in the same complaint. Initially, the trial included both defendants, and then there was a motion to sever. And the purpose of the motion to sever, the reason upon which it was given, was that there were two alternative defenses, competing defenses. So the defenses that were used based upon the motion to sever were inconsistent. So Jennifer blamed James. That was her defense. The guy who's not here was responsible for the gun stuff. The gun stuff meant the ordinary care that was not exercised, and it wasn't by me, Jennifer, it was by my husband. That was essentially her defense.
Let me ask you this question. What do you think would have happened had Judge Matthews not severed the trials? If they would have had to do these together, what do you think would have... Again, we don't know the outcome at this point, obviously with Mr. Crumbley, but what do you think would have happened?
I think they both would have been convicted.
Why? Because of... well, first, let me go back before that. Would you have a separate jury for James and a separate for Jennifer?
Yes.
Or would you... Okay.
Yes.
Okay.
Yes. But one of the things that would have... in this case, there were a series of text messages that were, I think, critically important on the demise of Jennifer, and those included the text messages from the shooter to his mom, specifically regarding the demons that he was seeing, the battles he was fighting. Those were all excluded in this case.
Rightfully so.
Rightfully so.
Yeah.
All right, well, we have to take a quick break, but we have uninterrupted coverage of the trial. Once it gets started, they are preparing to start in just a few minutes here on CBS News Detroit at 9. if they're calling someone.
Welcome back. We now want to bring in our legal experts to weigh in on the trial thus far. Terry Johnson and Rick Convertino join us today. We have been listening in. Oh, has it begun? Okay, well, we will listen in now to the trial. Let's tune in.
And you were here yesterday for Lieutenant Willis's testimony, is that right?
That's correct.
Okay. And you've had the opportunity as well to review surveillance footage of different facilities?
Yes.
Okay. Does that include surveillance footage of 1111 Bellevue in Detroit?
It does.
Okay. And do you recall when Lieutenant Willis was asked if he remembered if James or Jennifer Crumbley ever left the premises of 1111 Bellevue, he couldn't remember the answer?
I do recall that, yes.
Okay. Do you have a definitive answer for us?
Yes.
Tell us about that, please.
Yes. So in my review of the video from 1111 Bellevue, I did not observe Mr. or Mrs. Crumbley leave the premises. They did, like we stated yesterday, go to their car several times to smoke cigarettes and come back inside, but they did not leave the premises from what I saw in the surveillance video.
Okay, so we have surveillance video admitted already about 11:30 a.m., around noon a.m. with the time difference on the surveillance camera, that James and Jennifer Crumbley arrived in the parking lot. Is that right?
I believe that time is correct.
Okay, and then we saw footage of James Crumbley pulling the vehicle out and backing it back into the same parking spot?
Yes.
Okay, but they never left that location of 1111 Bellevue?
I did not observe them leave, no.
Okay. We heard testimony regarding certain foodstuffs were found in Suite 130 in that location?
That's correct.
In the review of your video, were you able to give us information regarding that?
Yes.
Tell us about that, please.
So in the afternoon, at some point, the owner of that art studio that they were staying in got into his vehicle, departed, returned a while later with white grocery bags, a bag of ice, and I think a case of waters that he made 3 trips in and out, carrying that into the apartment or into that unit. And then that was the person that dropped off those groceries.
Okay, thank you. I've nothing for that.
Ross. Very briefly, Your Honor. Good morning, Agent Brandon.
Good morning.
You testified that James and Jennifer left the building but remained on the premises.
That's correct. Yeah, they were a little out of view of the camera by the front of the vehicle, but from my observations, they would go out there for a few minutes and then walk back in.
From what you recall from your review of the information that you received during your investigation, it wasn't just once or twice, but they actually went in and out of the building multiple times that day, correct?
Yes, I don't recall the number, but it was probably north of 6, and sometimes it would be both of them, sometimes it would just be Mr. Crumbley. You know, occasionally it would be Mr. Crumbley in particular would come out with his hood up or ball cap on and then walk back in.
And we saw it was snowing that day.
I believe it snowed in the morning, and then as the day went on, it let up. But yeah, it was approaching winter.
It was December in Michigan, so cold.
I don't recall the temperature, but yeah, it was December in Michigan.
You also, if you recall, there were times when Mr. Crumbley or his wife left the building and went back in during the day, but also at night.
Yes, it started when they arrived and then continued through the evening, yes.
As for the owner of the art studio going to get foodstuffs, I think is what the prosecution referred to it as, you don't know why he went and got it, you just know that he went and got it. Is that fair?
Correct.
No further questions, John.
No redirect, thank you.
All right, you may step down.
Thank you, Ron.
And who's the next witness?
Thank you, Judge. I did speak with counsel last night as well as this morning regarding our exhibits, and we approached earlier to talk about that. I will provide the court as well as counsel with our updated version. I have made a record before we started with testimony regarding exhibits that were admitted. I won't go through all of them, but I will rely upon the document that I provided counsel as well as the court that these exhibits are in fact admitted.
Yeah, we made an extensive record of which exhibits would be admitted last week, correct?
Correct, Your Honor.
That's correct. And the only exceptions that I did want to point out, we have an agreement to Exhibit 378. That's a redacted transcript of James and Jennifer Crumbley's interview video at the Oxford substation. We're in a stipulation to that. That's 378.
Ms. Lehman, did you have an opportunity to review that transcript?
I did, Your Honor. I have reviewed it. I have spoken with Mr. Keast about it, and we do have an agreement to admit that as an exhibit.
You believe it's accurate?
I do believe it's accurate, Your Honor, yes.
All right, I will admit number 378 then.
Thank you, Judge. And the only other two exhibits that are currently noted as exhibits on this list are 373 and 374. Those are not admitted and at this point will be omitted from the exhibit list.
373 and 374 will not be admitted.
Yes, Judge.
And Your Honor, I would like the opportunity, and I believe Mr. Case will do that, to give me a copy of that list to just ensure that I have the same number of exhibits that he has and to make sure that we agree.
Okay, sure.
And Judge, with that, people rest.
All right. Ms. Lehman.
Yes, Your Honor. At this time, the defense would call Karen Crumbley.
Good morning. Could you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, so help you God? Okay, and could you pull the door toward you?
I got it.
And have a step up. And have a seat. And then would you state your name for the record and spell your first and last name?
Karen Crumbley, K-A-R-E-N-C-R-U-M-B-L-E-Y.
All right, I'm going to ask you to keep your voice up.
Okay.
All right, take a deep breath.
Okay.
All right. Go ahead, Ms. Lehman.
Thank you, Your Honor. Good morning, Ms. Crumbley. Can I call you Karen?
Yes, ma'am.
Thank you. Karen, I am going to, again, ask that you keep your voice up. You are a little soft-spoken, so I want to make sure that the jury in the courtroom can hear you, okay?
Okay.
I just have a few questions. How are you feeling today?
Good.
Are you nervous?
Well, I mean, yes, a little. I mean, I'm all right.
I'm going to take you back. Well, let me start with this. Do you know James Crumbley?
Of course, yes.
How do you know him?
He is my brother.
Do you know his son?
Yes, I do.
I am going to ask that you not say his son's name. We do have some direction from the court not to use his son's name in court.
Okay.
And what is his son's relationship to you?
He is my nephew.
We're going to be fairly specific. Where do you live?
I live in Willaca, Florida.
Tell the court a little bit about yourself.
I was raised in Jacksonville, Florida. I went and graduated high school, and then I got my medical assistant degree and did a few times in New Hampshire at Dartmouth-Hitchcock Hospital, and then came back to Florida. And I was in a car accident where I lost my right leg, and now I stay in a town that is peaceful, and I have 4 children and 2 grandchildren.
How old are your kids?
17, 18, 23, and 25.
I'm going to take you back to 2021. Where are you living in 2021?
In Willaca, Florida.
Specifically, I'm going to ask you about April of 2021. Do you recall what was going on in April of 2021?
My mom was in the hospital. My mom passed away April 6th of 2021.
Do you recall if you saw James or his son in April of 2021?
Yes, I did. My brother James was there in the hospital with us when my mom passed. And then my nephew came down, I believe, the day after and stayed for the while we had those services. And then we had like a memorial thing, like get together with everybody, cookout and stuff. And then we had the services, the funeral services. and things like that.
You said your mom passed away on April 6th of 2021?
Yes, ma'am.
Do you remember exactly that your nephew came down on the 7th, or are you not sure of the date? And if you don't know, it's okay.
I know that they left when they found out that my mom had passed. I believe my nephew and his mother.
For a second. Who's they?
My nephew and his mother drove down to Florida from Michigan when they'd find out, and believe they got there maybe around on the 7th that they arrived.
Okay. So you remember that you saw your nephew maybe the 7th. It might have been the next day, or maybe you're not sure.
Right, yes.
But it was shortly after the 6th.
Yes, it was very shortly.
While your brother and his son were in Florida, did you spend time with them?
Yes, I did.
Okay. Obviously, it was a difficult time with your mom passing away.
Yes.
Do you recall seeing anything concerning about your nephew?
No.
Do you recall him saying anything concerning to you?
No.
And if I ask you about if you recall if anyone...
Will you keep your voice up? Just
Yes.
I want the jury to be able to hear.
Okay, I'm sorry.
Thank you, Judge. When I ask you if you recall hearing anything or anyone saying anything, I don't necessarily want to say what they said.
Okay.
That's not allowed. But just if you recall hearing anything.
No.
Do you recall having conversations with your brother where he expressed anything concerning to you about his son?
No.
Do you recall your brother expressing any conversations he'd had with his son that were concerning to you?
No.
Do you recall how long they were there?
I think I'm not honestly too sure. 1.5 weeks, maybe a week.
Okay.
For sure, for a week.
So it was more than a couple of days?
Of course, yes.
And you saw them more than one time?
Yes.
And when I say them, I mean both your brother James and his son?
Yes, ma'am.
Do you recall seeing James and or your nephew any other time in 2021?
Yes, I went to Michigan with my father and my stepmother to visit. It was actually he knew my father was going, but I was a surprise to my brother. And we went to Michigan. We stayed at their house for about a week.
When you
about
say
3 or 4 days, maybe.
When you say you stayed at their house, whose house did you stay at?
My brother James's house.
And was his son there?
Yes.
And you stayed there for a few days?
Yes, ma'am.
Did you spend time with James and your nephew in those few days?
Yes, ma'am.
And I'm going to ask you the same thing. Do you recall seeing anything concerning?
No.
Do you recall your nephew saying anything concerning to you?
No.
Do you recall your brother talking to you about concerning conversations he'd had with his son?
So I just have to object to that question. Honestly, I should object to the last question regarding April as well. She can testify as to what she observed and but not what James said or not said.
Yeah, correct. Yes.
From your observations, did you see anything concerning in June of 2021?
Absolutely not.
And did you speak with your brother after June of 2021?
Yes.
Did you speak with your nephew after June of 2021?
Not directly, no. I heard him in the background, tell him I said hi, he said hi, things like that, but not directly, no.
So based on those, they weren't direct, they were kind of in the background.
Yes.
Did you observe anything concerning with your nephew between June of 21 and, we'll say, November 30th of 2021?
No.
If there had been anything concerning that you had observed, what would you have done?
I would have addressed it, and if I would have known anything, I would have talked to him, I would have took him home with me if there was any kind of inclination that anything was wrong.
Would you have made your brother aware of it?
Of course.
Did you ever make your brother aware of anything that you were concerned about?
No, because there was nothing I was concerned about.
I have no further questions, Your Honor.
Ross?
Good morning.
Good morning.
My name's Mark. I'm going to ask you some questions. If anything I ask is confusing or sometimes I kind of go on a little bit, just let me know and I can rephrase the question. Okay. Now, James Crumbley is your brother, obviously.
Correct.
And we refer to him as a shooter. He's your nephew?
Yes.
Okay. The last time you actually saw the shooter was June of 2021? Your nephew?
You mean in person?
In person, yeah. The last time you saw him?
I think, Your Honor,
Oh.
But she's hesitating. I think I know what she's hesitating about. Do you want to discuss it at the bench?
Can we approach? Yes. I think I know what it is too.
Okay.
So we have, they have caught audio in the courtroom right now as the defense and prosecution approach the stand to discuss a question with Judge Cheryl Matthews. We know that Karen Crumbley, the sister of James Crumbley, is now testifying this morning. It wasn't clear coming into today whether anyone would be taking the stand on behalf of the defense.
Go ahead, Mr. Case.
Thank you.
Listen back in.
Before the shooting on November the 30th, the last time you saw your nephew was in June of 2021.
Correct.
Okay, and the last time you saw him before that was in April 2021.
Correct.
Okay. And you, from the time of actually, you may not know this, but everybody's phones in this case were seized and analyzed. Did you know that?
Yes, sir.
Okay, including your brothers as well as your nephews?
Yes, sir.
Okay. So you're not here to tell us that you had a particularly close relationship with your brother, is that right?
We had a close relationship, but we lived in two different states, so it was mainly, it wasn't like close.
Well, you wouldn't talk very often.
At least maybe once a month.
Well, according to the phone records on your brother's phone, it was far less frequent than that. Does that sound right to you? And I'm not trying to trip you up.
No. We talked on social media as well.
Right. So there's call logs, actual device to device.
Right.
Then there's Facebook calls as well.
Correct.
And I show 2 Facebook calls.
Okay.
And then there's instant messaging, and there's 22 instant messages between you and your brother.
Okay.
And that's the entire year of 2021.
Okay.
And then there's some group Facebook messages with other members of the family.
Okay.
Now, your nephew never wrote you a note that said, "Help me," did he?
Sir.
And he never drew a picture next to that note with a gun, did he?
All right, the feed there on the stream seems to have just frozen temporarily, obviously in a very critical moment. We're hoping that comes back soon. As soon as it does, we'll go straight back into the courtroom, but we're still here with attorney Rick Convertino. Rick, what do you make of this move to bring Karen Crumbley to the stand?
Unnecessary. It's kind of a desperate attempt, I think. I would not have done that. She's being treated as a character witness at this point. A character witness is allowed. When you give character evidence, it's a very dangerous thing because you can say give information about the person's character or their ability to have a certain trait, maybe truthfulness or honesty, and then it allows the prosecution to go back and to demonstrate to that witness all of the things that he or she did not know, were not made aware of. And he just started doing that, and he said, you didn't have a real close relationship, not a lot of contact. She admitted that. And then he started to say, had you known that your nephew didn't ask you cry out for help to you, no. Didn't draw pictures of a gun, no. Didn't do all of these things in the journal, no. And so she's being, had you known all these things, would that have raised a concern? And she'll have to say yes. If she doesn't, she'll have no credibility.
We see another feed has come up. Let's try to listen into this one.
Done for your kid, that would be out of the ordinary.
Yes.
Thank you.
Redirect?
Yes, Your Honor, thank you. The prosecutor
Out of the ordinary.
Yes.
Thank you.
Redirect?
Yes, Your Honor, thank you. The prosecutor asked you about guns in the family home. And you were aware, or let me ask you, were you aware in April or June of 2021 if there were firearms in James Crumbley's family home?
Yes.
And what do you know about those firearms, if anything?
I know that there was a Derringer because I saw and held it myself when I was there in June.
And how did you go about seeing and holding it?
He took it out of his room. I had brought it.
Let me stop you. Who's
Okay,
he?
sorry. My brother,
Okay.
James, took it out of his room to show, because it was, I guess it's maybe like an antique kind of ish gun. I'm not sure. I don't know really too much about them, but and I wanted to see it and I hold it, and it was very heavy. And then afterwards, he put it back in its case and brought it back into his bedroom.
Okay. You said you're not very familiar with guns, right?
Correct.
The prosecutor asked you about a statement that you made about getting a gun for your kid would be, I don't remember the word he used, odd or something along those lines. Is that right?
Yes, ma'am.
Okay. What did you mean by that? It sounded like you were trying to explain that to the prosecutor, and I don't know if we heard it.
I mean, if you're getting a gun specifically for your child to use at his leisure, that would be wrong. But with adult supervision, and I don't see any problem with it.
I have no further questions, Ian.
Just real quick, Rick Cross. When you were there in June, here in Michigan in June, I think, right?
Yes.
Okay. And James went and showed you the .22 caliber Derringer, the small gun?
Yes.
Okay. You said he went and where he kept it in his room?
Yes.
Yes. And the whole family was there?
Yes, sir.
Okay. I have nothing else. Thank you, Judge.
Well, you can step down in your excuse. I'll watch the step right there.
Yes.
Thank you. All right, who's the next witness?
No further witness.
Yvonne?
Just to confirm, Judge.
Yes. Oh, yeah, that's the Yes. Yes.
I knew you did.
Yes.
No rebuttal.
No rebuttal. Thank you.
Just for the record, Ms. Crumbley, who just testified, is in the courtroom. I believe that. Is there any objections?
No, she can say she's excused.
Are there any additional witnesses?
Not from the people.
None for the defense attorney.
All right. Brooke?
Out again as they discuss matters at the stand with Judge Cheryl Matthews. Terry, what do you think the benefit was, the purpose was to call James Crumbley's sister to the stand?
I don't know. I don't understand it. We talked right before the prosecution rested. I believe that the defense is at worst case equal, which means maybe a hung jury, but I don't know that this did anything at this point. I'm kind of mystified. I don't know. I know I keep saying that, but I'm just kind of, you want to bring a defense witness up that's going to add something or dispute something that the people have said. And here is a person that's from Florida. This is the aunt of the nephew, the aunt of the shooter. And realistically, what does she know? She doesn't see him every day. I believe the prosecutor started eating into that, he never texted you for help, you guys aren't close. If I'm a juror, I'm asking the same question, why? What does this do to help your case one way or the other? And I don't think it did anything.
Yeah, it almost felt like they were about to get somewhere, Rick, but I didn't notice it. Did you see anything that made any sense?
Well, there was, no, I don't think it was, it expanded or, moved the ball forward in any way for the defense. In fact, it may have hurt, because this is a chance for the jury to see, okay, now here's your case, and they'd necessarily give credibility to to the defendant's case, that they're putting on a case at all when they don't need to. So I don't think it
waste of time.
Yeah, I think it was a waste of time, and I think it hurt the defense.
Jurors don't like wasting time, unnecessary witnesses, especially being there, 5 days now.
I think she was on the stand to show that this was an ordinary kid who had ordinary desires, aspirations, etc., and that if there was anything unusual or any mental illness or any problems, that her brother would have told her, and he didn't. That was in sum and substance what the purpose was. Now, when the feed broke for us, we weren't able to hear. There were some questions started by the prosecution regarding, did you know that he had asked for help from his parents? Did you know that he had written this on a math sheet? The blood everywhere. I think that's where, and then it broke off. So I'm not sure how deeply that got into. Those would have been very problematic for the defense.
Okay, we're going to pick this conversation back up for you in just a moment. We have to take a quick break. Again, uninterrupted coverage available on our stream, cbsdetroit.com, the CBS News app, and Pluto TV. We'll be right back.
All right, I apologize. I was trying to see if your lunches could be here earlier. So your lunch will arrive at 11:30. Your lunch will arrive at 11:30, and we'll be hearing closings at 12:30. All right? So I need to tell you that during the trial and between now and the time that you hear closing arguments, you must not read, listen to, or watch any news reports about this case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. Please do not go on social media. Please do not post, go on Facebook, do research, and discuss the case with anyone. We have come this far, all right? So please follow my instructions. You're going to be free to go. Your lunch will be delivered to your respective jury rooms at 11:30. But I have to caution you, there's people in the courthouse. There are other trials going on. There is a ton of media here. So I need to trust you to not interact with anyone or listen to anyone talking about the case, or you get it, right? Do you guys get it? You get it?
Yes.
Okay, I've told you a lot of times, right? So at about 11:30, your lunch is going to be delivered to the jury room. At 12:30, we'll hear closings. It's hard to predict what's going to happen, when it's going to happen. So lunch will be at 11:30, and then we'll have closings at 12:30. Do you have any questions about the schedule?
Can we go outside?
Yes.
As long as we're cautious and don't talk.
Yes, it's a beautiful day. You can enjoy the sun, take a walk around our beautiful Oakland County campus.
I'm doing it every day.
You've been doing it? Okay, good, good. Whatever you want to do, just please avoid people because, you know, not everyone is as well behaved as you 15. Let's put it that way. All right? Anything else about that? So your lunch will be here at 11:30 and then we'll hear closings at 12:30. All right? Thank you.
All rise for the jury.
You may be seated. I'm thinking it was the jury. Okay. All right. So before you depart, you did change that jury instruction, and then I'm going to give you the jury instructions. If you have a certain order, I have them in a order that I think is logical, but if you want to change any of it around, you can do it.
The only one I have noticed from last time, Judge, is they have 20.30A after 1613 instead of in the middle. Last time it was in the middle. It didn't seem to really make sense. So
20.30A and 16. Okay.
yeah. And for reference, that would be right in front of 1615.
All right. Anything about the jury instructions, Ms. Snyder?
No, Your Honor.
I'm going to give you a set of them to make sure that you agree with them before closings.
Thank you, Your Honor.
Ms. Lehman, would you like to inquire of your client?
I would, Your Honor. Mr. Crumbley, will you please stand up? Thank you.
Mr. Crumbley, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the true self you got?
I do.
All right, you can put your hand down. And would you state your name?
James Robert Crumbley.
All right, go ahead, Ms. Lehman.
Thank you, Your Honor. Good morning, James.
Good morning.
You know that you and I have talked about your trial. Is that right?
That is correct.
We have talked about how the trial will go.
That is correct.
You know that when you were accused and charged with these offenses, that you have the right to remain silent.
That is correct.
We discussed that that right carries through the trial.
That is correct.
You and I have discussed the whether or not you would testify during your trial.
That is correct.
We talked about the benefits of you testifying.
That is correct.
We talked about the risks of you testifying.
That is correct.
And we've talked extensively about whether or not you would testify.
That is correct.
And knowing all of that, is your decision to testify or is your decision to remain silent?
It is my decision to remain silent.
All right. Mr. Crumbley, do you have any questions for me, or do you need any further discussion with your attorney?
No, I don't believe so. Thank you,
Okay.
Your Honor.
Okay. All right. I think we're releasing the jury right now. I want to caution everyone that's here to be cautious about interacting with anyone in the courthouse. If someone were to say something or do something in front of one of the jurors, it could be devastating to this process. So I know emotions have been running high through the whole trial, and I'm just asking everybody to please, mind where you are and what you're saying and who you're interacting with. All right? Starting over would be devastating for everyone. All right? So are they released? Okay, so the jury is released. I'm going to make sure no one's in the hallway before you take them down. So we're going to have closings at 12:30.
Yes, Your Honor.
We'll have the instructions available for you before that.
Thank you, Your Honor.
Oh, 20 point. If you put them in the order you want them in,
I'll take care of it.
Copy them. Okay. So we have them. She modified the expert witness, right? Yes. Okay.
Thank you.
So if you return them to us, we'll make a copy for each of you, and we'll also make a copy for the jury. Okay?
Thank you, Judge.
All right, so I'll see you here at 12:30. You can take the defendant, but let me make sure that there's no one in the hallway. All right? And I'm going to ask you all to remain seated while the defendant is taken out of the courtroom. Okay.
Back to this first.
That can be it.
Okay.
You didn't move anything. We did.
James Crumbley, father of the Oxford school shooter, has just been walked out of the courtroom. Those closing arguments are set to begin today at 12:30.
This trial is really fast-tracked from yesterday when the prosecution said they were almost prepared to rest their case. We weren't quite sure. We did see one more witness answer some questions today to clarify. What are your thoughts, Terry?
I think it should go. You know, when you have, I call it the triangle of good. When you have a good prosecutor, a good defense attorney, and a good judge, things move pretty quickly. If one of those three legs are off, it's up to the other two, whether it's the defense attorney and the prosecutor to bring the judge along or vice versa, whatever it is. Here, I think you've had very good, competent representation by both the state and by Mr. Crumbley, and I think it's moved along very effectively, as it should. So I am not surprised that we're done today.
That's something else we've been wondering about. Are we going to hear from James Crumbley himself? And we just heard today that he is not going to be speaking.
Right.
Your thoughts on that?
I think that it's a wise move. I don't know what Mr. Crumbley has to gain at this point by taking the stand. I'm sure the jurors are going to say, God, we wanted to hear from him, but the judge is going to instruct them. You can't hold that against them. And I don't think they're going to.
Rick?
Yeah, I think that it was a good idea not to have him testify. It wasn't necessary for the case at all. I think this case is, we're going to be able to make a competent prediction after closings, because this whole case is going to come down to the closing arguments. Both sides are just going to have to argue the hell out of the pieces of evidence that they have in favor of their case, and I think that the case will be decided in closing arguments.
And speaking of those closing arguments, we've essentially already heard what Karen McDonald is going to say on behalf of the prosecution. I mean, I would assume it's a similar play. No. Really? You think this will be completely different? At least in terms of hitting the emotion, hitting back to what this case is about, and, whose lives were lost.
I think the basics she's going to do, but I think she's going to have a little more difficult of a time turning back and saying, he is the one. You know, he is also responsible for what the shooter did. When you look at Jennifer Crumbley, again, just as number one, she took the stand. I don't think she did a good job. She was very stoic sitting there at the table, showed very little emotion, wasn't likable. I think she's going to have a hard time at this point trying to turn that around to say this is a very bad man. Because again, if we go back to the first case, I argue they're being the prosecution, their whole argument was, listen, these are bad parents. This is the bad parent argument. I don't think this, and I think the defense attorney here did a good job of not making this about his parenting skills and more about his knowledge of what he did and didn't know, and what he did and what he didn't do. So That's why I think it's going to be different.
Just seem to stick to the facts.
I think the argument, much like the case by the prosecution, I think the closing argument is going to be the same in sum and substance. So I disagree with my very esteemed colleague. I think that Keast will do the closing argument. That'll be the difference. I think he'll go, seriatim through the facts, apply the facts to the law, and then again, argue the hell out of it, because there are gaps in this case that weren't there in the first case. It is a different case in the sense of the defense having placed some, strategic holes in the evidence. She's giving the jury the opportunity to view the same evidence that was presented in the first case in a different view, in a different alternative manner, in little things and big things. I think the risk of flight, the consciousness of guilt in the flight issue, when they were allegedly fugitives, I think has been diffused greatly. I don't think that the jury is going to consider that they were fleeing the country or fleeing for their own personal protection, but that they were scared to death, that they didn't know what to do or where to go. They were relying in part on the misinformation that they were getting from their attorneys, and so they were just confused people who were scared to death. I think that's a different vantage point than we saw in the first case, and so I think it's going to come down to really two things: the journal and the closing arguments, because we're going to be able to see how the defense can take all of the areas that she had challenged, effectively, and put those into one closing argument to convince that jury that there are reasonable doubts here.
How long do you close if you are the defense?
45 minutes.
That long? Okay.
Yeah, I would say 45 minutes. I would say an hour and 10 minutes for the prosecution.
Including rebuttal?
Yes,
or? Okay.
yes, including rebuttal, yes.
Because remember, just for your viewers, there is, the people get two shots at the apple. They get the first, and then the defense goes, and as Rick has said, then you get the rebuttal. So they get to come back because the burden is on them, they get the last word. But to me, I would, if I'm the defense, I'd probably do a half hour at most. And I'd harp on key points. Not only is there doubt, but I hold up that exhibit where the shooter said, ladies and gentlemen, the shooter said himself, I have to find the gun. So he exercised ordinary care.
Interesting point, because Meredith and I were talking about this at the break. I have to find the gun, my dad hid it. We had Karen Crumbley testify that she was personally showed this Derringer because it was antique-ish, if you will, and that she held it and she thought it was heavy, etc. And then on recross, there was one question, and that was when you were shown this weapon, you were shown it by your brother, yes. He got it from his bedroom, yes. Was everyone in the room at the time? Yes. The whole family? Yes. He said yes. I think the purpose of that question was to demonstrate that the defendant, James Crumbley, took the gun from his bedroom, showed everybody, put it back in the bedroom in front of the whole family, intimating that imputed knowledge of where the other guns were onto the shooter. That was the purpose of that question.
But there's two things to that. Number one, a Derringer is a one-shot gun. Two-shot, okay. But here's the other part of this. The other part of this is, at that point, that 9mm that he purchased a few days before was not in the house. So we don't know where that was allegedly.
No, I understand.
And those are questions
for the defense.
The shooter did find elements of the gun in the bedroom.
Right. That's where it was.
Yes.
So
with the ammo.
What you're saying is this was his hiding place.
This was his hiding place. He made everyone aware that's where he hid the weapons, if you will, and that was a place that the shooter was known to look and did look.
Yeah, but here's the thing, even so, let's take that a step further. If I lock let's say there was a cable lock that was placed on it, and you know, can those locks be cut? I believe that was a question that was asked by the defense attorney and the ATF agent. Well, yeah, they can be. Okay, well, can the locks be, you know, yep, they can be. So again, the question comes down to, as you've said many times, ordinary care.
Exactly.
Was it ordinary care to hide it? And if he hid it, just because you found it doesn't mean that it's not ordinary care. I think if the gun would have been laying out on the coffee table or on top of the fridge or something like that, we might be having a different conversation.
Yeah, and that's the gravamen of her argument, that he hid the gun, that he said he hid the gun in the journal, and that, you know, that was ordinary care, along with other things that the father did that were ordinary care.
I would argue, however, on the flip side of this, the text messages between the shooter's only friend, who we know quickly departed from his life a month before the attack, revealed that sometimes guns were left out. And he was playing with the gun, he took a picture of it and sent it to his friend and said, my dad left this out and I'm playing with it. So there are two pieces of evidence presented in this trial that are conflicting.
Sure, but here becomes a bigger question to me. The bigger question comes down to what triggered this? Why this day? And I don't believe it was the fact that a firearm was purchased a few days before, because again, it's my understanding there were other guns in the house, right? So what was the triggering point that did this? And if we don't know what that triggering point is, you know, because I think the prosecution is saying, well, he purchased the gun on Saturday, he went to school on Tuesday, because the gun was purchased Saturday and it wasn't put away. And I don't remember, and maybe Rick, you can help me here, where were the other guns? Were they locked? Where were they found in the house?
Around the same area. The Caltech and the Derringer were in the same area.
So basically,
they were under some clothes.
Yeah, but the question I have is, why didn't he take one of those? Obviously, we know why he didn't take the Derringer.
Oh, he says why. He says why he didn't in his journal. He
Because
says the Caltech was a .22 and it wasn't an effective killing machine. That's why he needed a 9mm. He asked his dad for a 9mm. His dad said, according to page 5 of the journal, his dad said, we can't get a 9mm right now because we have some financial issues. And then later he, you know, gleefully says in the journal, oh, you know, I got my gun, but I can't find it. My dad hid it. And then he says, found it. So the journal kind of walks us through, you know, step by step of his thought process. And, you know, he must have had some kind of psychotic break to go from these thoughts to the actual act.
Yeah.
But he does say in the very, very chilling language, he says, many people have one day to live.
Yes.
They have no idea they have one day to live. So man, that was some powerful.
Right, but here becomes the question, going back to the defense's opening, what did he know? Did he know that this kid, his son, was about to do this? And if he had some knowledge of it and did nothing to stop it, then I think you potentially have a conviction. But what she's shown since her opening is he didn't know, because again, it's not like
He
this.
didn't need to know. Remember, Terry, you know, as you know.
Well, I know you don't need, well, but here's my point in this. The point is, in order for me to, if I know that you're psychotic and you want to get a gun, and I just hide it under the clothes, that's not, in my opinion, ordinary care.
Right.
If I know you're psychotic and you want to do something to someone, I'm going to take extra steps to do things. I'm either going to get a lockbox where I hold the only key. I'm going to do other things. So I understand it's not an element, but however, I think the jurors are going to go back and think about that, you know, from the standpoint of even this journal. Dad didn't have access to the journal. They didn't know a lot of things until these things actually manifested themselves.
But he knew it existed. He told his son, write in your journal.
Yeah. But that, okay, I understand, but that doesn't mean that Dad went in and looked in his journal. A lot of kids, especially, well, I don't want to say especially young girls, maybe I'm dating myself a little, but, you know, a lot of kids have their private moments and they put them in a journal. A lot of parents will not go through and say, you know, and again, it gets back to this point. If my kid is off and something's going on, yeah, I might go look in his journal. But if I don't believe my kid is not acting normal or he's doing everything he should, why would I go in there? And again, we're looking at this from what happened after the shooting happened, not before.
Well, let's look at it from before.
And that's why I say this gets down to what did they actually know.
Let's look at it from before. What events occurred in the life of the shooter and the family that should have caused one or both of these parents to act. Lost his grandmother, traumatizing. Lost his only friend that he had 22,000 text messages with, the only person that he associated with outside his mother and father, the sole person that he relied on in confidence in many occasions. Taken out of his life, abruptly and
He's doing a good closing.
Yeah. His dog dies.
Yep.
And so all of these things are happening. They're getting contact from the school that he's problematic in school, both in grades and he's drawing.
Yes.
He's been seen viewing violent videos on his cell phone during class. He's falling asleep in class. He's not paying attention. His grade. No.
I mean, the violent videos were a day before.
He was looking at bullets.
Yeah.
I believe.
The day before, right?
No, but not the day before. That was sometime before when they gave the voice. They made the voicemail call to Jennifer,
which was I believe it was a day or two before. It wasn't weeks or months before.
I think it was a week before.
But here's the point to all of that. Yes, but here's the thing.
So at some point,
how many parents are going to say, "Oh my God, I think my kid's going to kill someone. I need to do."
But that's not the point. See, because there's not a I said before, a sentient being in the world who, had they known or were aware that this would have occurred, would not have done everything in their power to stop it. Of course. And that's the slippery slope. We're well before that. We're at ordinary care. What should they have done in an ordinary care manner to have prevented the natural consequences
minus
of this act?
Minus the gun.
What do you mean minus the gun?
Minus the firearm.
The purchase of the firearm?
Well, the purchase, I'm not even going there. My question would be, what more would you, other than, let's say, locking the gun, hiding it, not having the gun, what more?
Well, that's a critical piece of evidence because you kind of can't.
But there were guns already there.
But they were 22s. There was a 122, BB guns, and
a 22 can kill someone.
Well, it can theoretically. It can't.
No, not theoretically.
You're not going to walk through a building and just discharge 32 rounds of a 22 Kel-Tac and kill 4 people and wound 7. He was well aware of that. He said that in his journal. But he's also proficient,
and he's been training.
You have to be, an expert to. No, you can't kill a coyote with a 22, for Christ's sake.
Well, if you're a good shot, you can. If you hit it,
of course.
If you hit in the right place,
yeah.
and
come on, we're talking silly. You're not behaving yourself again this morning.
Okay, I think this is a good point to interject, if I may.
I agree.
Yeah, I was thinking the same because I was so.
I agree. He goes off the rails. I get it.
We're talking about coyotes. I don't even know where this has gone.
We can't forget the fact that he also was begging his parents for mental health treatment. So that's also part of the equation as well.
And something I keep coming back to is that his parents and the school counselors were concerned he would turn a weapon on himself.
Correct.
It was their immediate thought was he might hurt himself.
Yes.
So when we talk about ordinary care, if this was running through your mind as parents, it's something that you said before. If I knew my child was having a psychotic issue, was having some sort of break, I would immediately hide the weapons. I mean, secure the weapons.
So let me ask the question. If you're sitting in school at that point, and you don't believe that a firearm is there in the school, because let's face it, no one believed it was there. The school officials didn't believe it. They took no actions. The parents didn't believe it. They believe, again, let's go back, he could be a danger to himself. So what would I do? Well, I'd call the spouse and say, hey, this is what's going on, or as we're walking out, make sure those guns are locked, make sure they're whatever, because again, no one believed that firearm was there. And what the school did is say, hey, we believe he, being the shooter, needs to be with someone. He should not be alone. So at that point, no one knew the gun was there. Because again, the threat was not to everyone else, it was to himself. And if you believe the firearm is not there, I mean, that's critical to me.
It's the answer that you're seeking. I mean, that's one of the prongs. There's the ordinary care opportunity to take their child home and do what they're advised to do, which is to,
and they
to
should
seek
charge
mental health.
and Karen McDonald should charge the school under the same thing.
All righty, all right.
So you disagree with Vin Johnson's lawsuit?
No, I personally I do not. I think the school should be held liable, civilly liable. I think they made dramatic errors that should result in recompense. I think that's quite clear. Their actions were remiss, but I don't think that it rises to the level of criminal culpability.
Sticking with this, do we know from all this evidence we've seen throughout the trials, did the school ever ask the Crumbleys if they owned guns at home, if they had guns at home, if they had access to guns? Wouldn't, of course, hindsight is 20/20. Wouldn't you ask if this child is drawing,
especially if there's conversations about him hurting himself, possibly
researching bullets, drawing guns, drawing blood? Wouldn't that be the first question you ask?
Would. Well, you know, generally, listen, you take a kid nowadays to the doctor that, for some reason, I don't understand why, are there guns in the home? A kid is talking about hurting themselves. A counselor's always, do you have any guns or other weapons in the home? I don't know why that question was not answered. But let's assume it was asked at that point, right? Would you expect the Crumbleys to say, well, yes, we purchased a gun, it's at home? Do you think just by asking that question, someone would say, geez, light goes on, let me look in his bag that the counselor had already said is, boy, this is a very heavy bag. Let me look in this bag and see if there's a gun in here. I mean, I don't know that asking the question would have resolved the issue there because no one looked in the bag.
Or does he have access? Not only that you have them at home, does he have
access?
You remember, Meredith, that a large part of the cross-examination regarding the BATF agent, in this case the officer in charge, co-officer in charge, was that this was a gun community and that guns were common in the Oxford community, common for kids, common to draw guns, common to think about guns, common to talk about guns, guns regarding hunting, guns regarding sport shooting, that this was a particular area. That was the testimony where guns were common and parents and their children often target practiced and hunted together. So that does obviate some of that. I think in this particular community, for whatever reason, that was the testimony in this case, that it was a commonality, not an unusual thing. And maybe that's why they didn't ask.
Very interesting. Good points. So what do you think is going through the mindset of the defense attorney right now? She has about 2 hours now until she can present her closing argument.
Hyper-focused on what's ahead. They have the issue of jury instructions. They have to go through the jury instructions, make sure that they're all in order, and the evidence, and make sure that that's in order. So those are competing time interests for her, unless she has somebody to help her with that, which typically they would, a defense attorney would, but hyper-focused, questioning whether it was a mistake not to have him testify or not at this point in time, kind of being, but you have to put that aside and focus on this closing argument, because this will be, his life is at stake, his liberty interest is at stake, and it relies, I don't want to be melodramatic, but in some cases a closing is not as important as others, but in this case it's absolutely critical. You have to crystallize, concretize the evidence in your theory, rebut the evidence in your opponent's case, and focus it and dial in that jury. It is critically important to hit a grand slam in this home run.
What I like to do in my closings is I always like to put a question out that the prosecutor can't answer. and I'd like to do that. And, you know, ladies and gentlemen, they're going to tell you this, this, and that. But before I sit down, I want you to make them answer this question for you. Make them answer this question. And sometimes the prosecutors take the bait and they go off a rabbit, you know, down a rabbit hole, and it's like they can't answer it. Other times it's like, I don't need to answer that. You need to focus on this. The defense attorney needs to focus them on 1, 2, or 3 things that say this is reasonable doubt. You know, you start getting into, I was with one attorney one time, and she did 25 truths of what is, and I'm just saying, looking like, wow, you think people are really going to sit here and listen to 25 things? They're not. You need to give them 2, 3, at most 4 things to say, these are things that the prosecutor cannot prove beyond a reasonable doubt. And if they can't prove it, if you have doubts, they have doubts, you need to go back and say, check the box that says not guilty.
And what's critically important in this case is they have to overcome the community passion. And there is a community behind this jury that's being, you know, funneled through the jury. And you have to tell the jury, you know, they're not there to make an example. They're not there to get retribution. You don't want to say that directly, but you want to make sure that that message gets to them. And there are ways to do that, because this is a case of high passion, and you have to separate the passion from the conscious intellectual decision making, because in many ways it is a mathematical you know, equation. You have to come, the conclusion has to be guilty beyond a reasonable doubt or reasonable doubt. Those are the two sum and substances of the equation, of which you're analyzing all of the facts in the case. And so to overcome that impulse, you know, that human impulse to lash out, and this is the case where there's a lot of that.
Yeah, the defense also still has to recover from that high point yesterday after we saw that video. Because I imagine that had an effect on the jury.
Yeah, impassioned the jury. We heard from Andreas that there was at least one juror who was crying during that video. I mean, that's very telling. One of the things that we're kind of handicapped here when we're talking about a potential outcome or how the evidence is being viewed is I'm pretty good myself at evaluating another trial attorney's jury, and I can sit there and I can watch the jury and see reactions and kind of get a real good feel. We didn't see that. We're not able to see that, any of the jury's reaction or how they're maybe interpreting some of this evidence. But when you hear that a juror is crying, and it's not the first time that a juror has shed tears during the course of this case. That is that passion that I'm telling you about. You know, that's a very real wall there.
Somebody's going to pay.
Yeah, somebody's going to pay.
But do you?
And they know 2 people already did pay.
And that's what I was going to ask you. You know, would you, in your closing, if you're the defense attorney, would you say something along the lines, the person or persons who are responsible for this, they've already been taken care of. This is about James Crumbley and what James Crumbley didn't do. I mean, that might be a way to focus them back, because again, if they believe people have gotten away, you know, you're telling them no one's gotten away with anything. And my client, listen, he had no knowledge, he did what he was supposed to do. You have to be very careful, though.
There's an argument that would raise an objection for a mistrial. That kind of argument, you know,
so you got to be careful.
You got to be careful, yeah. I think they're aware, all but 2 of the Jennifer Crumbley trial and the outcome in the Jennifer Crumbley trial. I think that was elicited in voir dire. So I don't know. I wouldn't touch on that. That's kind of that's a risky proposition. You don't want a mistrial, you know, at this point in time.
Do you think you think Judge Matthews would actually declare a mistrial?
No.
Yeah.
No, but I think it's a troublesome spot for an appeal. No,
well, it only goes to appeal. It would only go to appeal if there is a conviction.
Oh, you're one of those guys?
No. I'm just saying it only goes to appeal if there's a conviction. Just stating a point. Just stating a point. So,
All right, gentlemen. Well, we'll continue our conversation, and also we will have this coverage for you once things pick back up at 12:30. We'll be back here over the air for CBS News Detroit at noon.
Clearly a pivotal moment.
Gun control, the economy, education. Both sides of the political aisle fight it out for power.
Bringing you the analysis that you need.
Thoughtfully, with context.
Be part of the conversation.
On CBS News Streaming.
Welcome to America Decides, Monday through Thursday at 5 p.m. Eastern.
An original documentary from CBS reports.
AI is among the most world-changing technologies ever.
Curing diseases, scientific breakthroughs, making lives better.
They can help us with medical discoveries, scientific discoveries, doing better agriculture, having cures for things like Alzheimer's.
It's also going to really transform the way we work.
The uplifting potential of artificial intelligence is limitless.
It gives you a friend, somebody to chat with 24/7. That is non-judgmental. He makes me feel loved and desired.
And so are its downfalls.
The problem with all this AI is that it's unpredictable and uncontrollable. The choices we make now will have lasting effects for decades, maybe even centuries.
The ChatGPT revolution, now streaming on the free CBS News app.
An original documentary from CBS Reports.
That Desired Farm is a wonderful place to raise children, and it still is.
Promises broken.
Black Americans have been the target of racism and discrimination pretty much from the time they acquired ownership in the land.
Costing black farmers hundreds of billions in generational wealth.
They did everything to make sure we were run off that land.
But communities are uniting to continue the fight.
Collective ownership is powerful.
To keep their land and their dreams alive.
To watch my children play on land that we own means everything.
So land is power.
Most definitely.
40 Acres and a Mule, now streaming on the free CBS News app.
All right, the House has just voted on a bill that aims to force the sale of TikTok or ban the app in the United States. Scott McFarlane is following all of this from Capitol Hill. He is going to join us on the phone. We're also going to get a report from Weijia Jiang, who's covering this from the White House perspective. But Scott, first, let's begin with you. Walk us through what just happened here.
Yeah, thanks for bearing with me. I'm in a part of the Capitol where cameras are not permitted. This bill to require TikTok to separate from its China-based owner or face a ban was like a 747 Vlad. It had the speed and force of a bill unlike one we've seen here in recent memory. It was just introduced a week ago yesterday. It sailed through a pivotal committee last Thursday, and then today, overwhelming vote of approval of this bill. You recall the U.S. House is in this strange state of dysfunction where every bill requires two-thirds majority to pass right now because of the gridlock, and it easily eclipsed the two-thirds threshold. Bipartisan support. There are Democrats and Republicans in leadership who back this thing. It now pushes to the U.S. Senate, but it's just striking how fast this went from start to finish. 8 days between introduction on the House floor to passage on the House floor. You just don't see that in this day and age.
So this is kind of interesting because I do believe the former president, Donald Trump, when he was president, was in favor of some sort of a TikTok ban, but he's done a bit of a flip-flop, and now he considers Facebook to be sort of what public enemy number one.
And some of his sycophants in Congress are also doing a 180.
Well, I'm curious about that, Scott. I mean, are we seeing the former president, Donald Trump's flip-flop on TikTok having an influence on how this vote may go moving forward into the Senate?
Yes and no. I mean, we've seen a couple of his supporters vote no today, even though they've been vitriolic in their criticisms of TikTok, too. I would name one of them, Matt Gaetz of Florida, who has been unambiguous with his concerns about TikTok, and he voted no on this bill today. But here's the thing. Donald Trump's been a little mushy on this. He's obviously supported a TikTok ban in the past. He was very vocal in his support of that. But his recent criticisms have been a little bit half-a-loaf. He's saying you can't ban TikTok or else you'll give Facebook too much power. And, of course, he doesn't like Facebook because after January 6th and the insurrection, Facebook banned him. But it's not a clear-cut vote this down or I'll come get you in your primaries type of denunciation. So there is some wiggle room for Republicans to vote against TikTok. But here's the thing. This still has to go through the U.S. Senate, and there's an awful lot of time and space for opposition to form and galvanize, including any opposition from Donald Trump.